Okay, I'm going to call to order this June 5th, 2025 meeting of the Underhill Planning Commission. Does anyone on the Planning Commission have any changes to the agenda? No? Okay. Well, we all know there's public comment because we received Dave's comments, so I won't ask if there's any public comment. I did want to ask everyone who is not on the Planning Commission just to introduce themselves for the minutes. Maybe start with the folks on the video screen if you don't mind. Russ, can you just give your name and address?
Yeah, Russ Vogel, 611 Pleasant Valley Road.
Thanks, Russ. And Michelle, maybe the same?
She might have screaming kids. Michelle Williamson, 623 Pleasant Valley Road. It's my wife.
Okay, and then obviously
Gordon Williamson,
okay,
Pleasant Valley Road.
And then caller 1. Okay, so we're not sure about that. All right, go ahead.
Hey, can you hear me?
Yes.
Hey guys, sorry, it's David. I'm just calling in. I expected to be back. I'm just down in Boston for work, and the express train that I had on the ride home. Yeah.
Okay, thank you. And then last but not least, Dave.
Okay. Yeah, Dave Sills, 625 Pleasant Valley Road.
Okay, thanks, Dave. Just 3 quick things, and then we'll go into public comment, which I'll turn the floor over to Dave. Those 3 things are, because I spoke to Brad and he said I should mention this. I thought they were all good things. One is from a process perspective. Whenever the Planning Commission ultimately comes up with a suggestion, just to be clear, from a comment perspective, there's still going to be 2 public hearings where everyone can come and say what they think, right? And then after that, it will go to the select board. So Brad just thought I should make it clear that this is far from the only opportunity to comment on this. Second is from a time limit perspective. I know we actually need to amend the rules, by the way, Larry, as a side note. We had put in a time limit rule. I spoke to Brad. Dave, you haven't been here before, so just give your comments and do what you need to do. Okay, it's not fair to impose a rule on you that everyone else didn't have when they first came in. So
I'm usually pretty brief.
I figured it probably doesn't apply, but just wanted to make that clear. What's fair is fair, right? So, and 3, I know you guys all know this, Gordon and Dave in particular, and Russ and Michelle, but, and I know it is ultimately very personal, could affect your life, and I don't want to ignore that. But so I just want to make sure that our job as the Planning Commission, if we do our job properly, is to come up with a set of rules, whether it's sawmills or firewood processing or anything else, where the rule works for everyone in the whole town. And to the extent we can, we want to get your feedback, Dave, and Gordon's feedback, and Russ and Michelle and everyone, and incorporate that. But I just really want to make it clear that at the end of the day, the DRB will probably ultimately have to deal with individual things. And we're just trying to come up with a rule that applies across town and is fair for everyone and works for everyone. So that's our whole goal. So does everyone, sound right?
Yeah.
Right? Okay. All that out of the way, I will shut up and turn the floor over to you, Dave. So.
Okay, well, I'll try and keep this concise. First off, I want to say my thanks for putting this off, my presentation off until today. I was out of town, a very important commitment. I couldn't be here. Number one, has everyone in the commission read this email that my wife produced?
Yeah, actually, I posted it to the.
Yeah, I know this, but did everybody read it word for word?
Has anyone not read it?
Can you recite it today?
Well, no, it's for her and myself. Oh, no, this one.
Yeah.
Did you get a chance to read it? Dave?
I think so.
Starts out on.
Yeah, that
Running this
include a incident with a logging truck.
Yes.
Oh, yeah.
That's the one. Yep.
Okay, I read it.
Okay,
Yes.
so everybody has. Okay, I'll try and be brief. I'll read this whole thing, but if everybody's read it, I won't. The bridge, of course, is a concern for for a logging operation going on, or log trucks going across our property. I know that may not be germane to what we're doing here, but I do have pictures, and the damage to the truck, to the bridge, is occurring on a regular basis. This is over the course of 3 weeks or so. You can see one picture where there is no apparent damage, and now with all this traffic, there's been a lot of damage. These just send around. You can look at them if you choose or not. Moving on to the driveway incident. My wife was, actually, I'd like to read that part, if you don't mind, to be concise. Is that okay?
Yeah.
Find it. Dave's account of the incident above on May 28th is as follows. While in my house, I heard Gordon start a 70,000-pound loaded log boom truck, which I realized after the fact. I went out to my gardens to listen as Gordon shifted at least 4 times as he drove his truck down the steepest pitch of the driveway. Pass this around. This driveway is not anywhere near close to current specs for town driveways. Well, Dave and I, immediately after I heard him apply his Jake brake, okay, Gordon shifted at least 4 times as he accelerated down that pitch. Of his driveway. Immediately after I heard him apply his Jake brake, in a failed attempt to slow down. As it turns out, my wife was on the same single lane driveway coming up as he was coming down. She had not been able to pull into one of the pull-off areas at the bottom of the steep hill, the only pull-off area. My wife and my little RAV4, and since no attempt at humor would have been flattened. We're talking about 70,000-pound big truck and a RAV4. The only option would be for both of those vehicles to go in the ditch to avoid it. Not one, but both. I walked within 100 feet of shared driveway during this episode and thought nothing of this, as this is the normal manner in which he drives his log truck down that hill. I've heard it countless times. I became aware of what happened to my wife shortly thereafter. On inspection of the driveway, I noticed marks on the driveway indicating some loss of traction of the tires on the driveway. In addition, will mention I used to drive 50,000-pound trucks in the city, so I do know a little bit about the weight and how long it takes to slow a big truck down. So that's a serious safety concern in my mind.
What's a Jake brake?
It's I don't know exactly how it works, but what it does is it causes back pressure. You shut the engine off. Gordon can explain it to you better. And it creates a lot of traction that braking won't do. Braking won't slow down a 70,000-pound truck.
It's engine, is it engine braking?
Engine brake, yeah, engine brake.
Jake brake is an engine brake?
Right.
So you
know how you
shut
hear
the
the-
engine off?
No,
Well, I'm not, I
Town
think there's a
shift.
switch.
it's downshift. You hear the engine like downshift and it gets really loud, basically, right?
Well,
I'll wait till my.
Okay.
yeah, okay.
Anyway,
Okay. Oh, these are some more pictures of that day. That's the that day when I went by. I'll try and summarize some of this. But there have been previous meetings that I've gotten notes on. And a lot of this started with the Gordon working at the Tisbert property near Vogel's.
Yep.
And Sikorsky. And so I'd just like to point out on February 14th, everyone here recognized the towns regulate sawmills and often restrict their location in commercial and industrial areas. Underhill does not have such a district. Regardless, we know from the Tisbert property dispute that allowing wood processors in more dense residential districts inevitably lead to conflicts over noise and hours of operation. So that's something that everyone had as a problem that you're aware of. On the same 214 meeting, these rules already provide, this is just a quote from section 314. These rules already provide a basis for the zoning administrator to issue a notice of violation to the property owner for noise levels that exceed 60 decibels and are not someone running a lawnmower or something else, but some other that represents a significant increase in noise levels in the vicinity of the use as to be incompatible with the surrounding area. That's a decibel limit of 60 decibels by town ordinance. Just to summarize, Tisbert's site relative to Sikorsky residence was 300 feet. That caused a serious problem. Vogel residence was 320 feet. Same thing. We went through all this last fall. I was at the DRB meetings. That was not nice. Williamson's site, where he operated last year, is 300 feet from our front door. So we're talking about the same situation. 300 feet, as I'll demonstrate, is nowhere near enough distance. I have a chronological outline. I think I might have gone over the top here with some of my stuff.
Yeah, I mean, can I just point out that we're not here to adjudicate a particular
I know.
instance, and those kinds of issues are probably best raised with a town administrator, who's acting zoning administrator now, if you're concerned about enforcement of our existing.
Well, I'm trying to give advice primarily about the noise.
Yeah.
And so I'll get a little more concise, and I'll be done here pretty quick.
Oh, go ahead. I was going to say something, but I'll wait till you're done.
So I would like you to each have a copy of this chronology, though. I think it'd be good for your basic general knowledge here. Sorry. There's this all statement. You can just pass that around. So I have points 5 and 6 about some of the previous drafts, and I won't go into it now. I have it all written out here, 500 feet. Currently, though, in the last draft, I noticed the same in this one, draft amendment dated 5/8/25, eliminate lot line 300-foot setback. Change section B to a 200-foot setback from any residence. I see now is 300. And keep 500 feet setback from home, childcare, schools, healthcare facilities. I have a little bit of experience in legal matters, to say the least. And what is the legal justification for inconsistency of setbacks from household residents to local childcare, schools, or anybody else? I don't think that's going to hold. How many are you familiar with Gordon's wood processor or wood processor like it? Do you have any idea, or have you ever seen one operate?
I have.
I have.
I have as well.
You've seen it out there, up out by the road. Yeah.
I've seen somebody else's.
This was a couple of years
Yeah.
ago.
Yeah,
Yeah.
sure. It's been going on for several years, 3 years, in different locations.
A couple of years, it was visible on the side of the road.
Have you heard it from the Tisbert property yet?
From,
Your house to the
when
Tisbert?
it was down by this side of the river, our side of the river.
Yeah,
it was
that was 3 years ago or so. Yeah.
On the other side, and you could hear it, it's not, it's close to our house as well.
Yeah, it's probably 1,200 feet anyway.
Right.
And now, I checked with maps and things, and now you're 1,200 feet from where Williamson is legally set up to operate his processor in Cambridge on the Tisbert property, which I think is great. The only other closer property owner is the Brown family, and I don't believe they're a whole lot closer than you are. As an aside, I know of a wood processor identical that is operated in Morrisville, and someone has a house about 1,000 feet, 1,000 feet is what they told me, from the wood processor. The process is much more volume. And she said it's noticeable inside her house, but it's not annoying. So that's 1,000 feet. I'm kind of diverging from my.
Well, one of my key questions for you, Dave, was do you have, in terms of your feedback, do you have as you've thought about it a lot, do you have a recommendation of what you think the setback should be?
Well, that's a good question. I would think a minimum of 500 feet, but it could be as much as 700 feet.
Mm-hmm.
And I'll play something for you that I've recorded. And believe me, I want anyone to be able to do their work in a safe and positive manner. So this is no slight against anybody, but it has to be reasonable. And that's one of the key things in all of this writing is it has to be a reasonable level of noise so that people can have a peaceful existence in their property.
Mm-hmm.
I'll try to sum up now.
Okay.
But since not everybody has seen this, these are pictures from the DRB meeting on the Williamson property. Oh, you can just take one pass it. I made a bunch. Each of you can take one. That has a 4-foot 2-inch blade, run with a 260 horse commercial diesel motor.
How many horse?
260 is the one in Morrisville. It's identical to yours. Or maybe you have different horse. You have bigger one, littler. You said something like 240, 260 at this meeting.
Me?
Yeah, you.
It's 74 horse.
That's not what you said at the meeting at the DRB on your own property. That's neither here nor there anyway. It's the level of noise. Now, I guess I don't need to get into the.
That's the nuisance ordinance,
Yeah.
which you probably saw. It looks like Larry has revised it so that it's referring back to the nuisance ordinance.
Yeah, I wasn't able to read this.
Not well, yeah.
Yeah. But in it, I'll just read this a little bit here. Noise that is excessive when measured at the boundaries of subject property and represents a significant increase in noise levels in the vicinity of the neighboring properties so as to be incompatible with the reasonable use of area should not be permitted. Now, one thing about this table though, it incorporates decibels and octave hertz. The hertz is what is really important. As you see that blade, it's not the motor. It's particularly disturbing. It's the blade when it cuts a 16-inch log or whatever size log it's cutting.
So are you comfortable with the way it's done now, Dave, where it refers to that chart?
Okay, yeah, if it refers to this chart and it sticks to this chart, that's reasonable.
Right, Larry?
It does, yeah, that was a change.
Yeah, okay, well, I'm glad to hear that.
It says, yeah, it refers straight to the chart now.
Okay, so, For an example, well, I don't need to go through examples because you have them. For an example, 75 hertz, maximum decibel level is 72. If you have 75 hertz of octave band range. If the octave band range goes to 1,000 or 3,000 hertz, 40 decibels is the maximum. So at one point, last summer, I registered on not an official device, but somewhat accurate device between 1,000 and 3,000 hertz at 75 decibels. That's 40 times the allowed level of hertz for that level of decibel.
Mm-hmm.
And one time, maybe I saw it run to 8,000 hertz.
Is this the recorded?
Yeah, I can, if you don't mind, you could pass it around or whatever.
This is from your report.
From inside my front door.
Inside.
Door's open.
Is that like a real, it really is that loud, or because you can turn the
That's-
volume up on the phone?
It's louder than that when you're there. I mean, that is what you hear when you're outside and
We have 350.
300.
Okay. Thank you, Dave.
You're welcome.
Does that, not to rush you, but does that,
Yeah, my stuff's all over the place. This is, oh, well, there's one more picture. That's the reading I took last year as well. You can just pass that around. 90 decibel. 300. Yeah.
so just, if I can, just to sum it up. So we, or make sure we're getting your takeaways. What do you feel the rules should say? That it should be a setback of 500 to 700 feet, and then it should refer to the nuisance ordinance.
Absolutely. Yeah.
Is there anything else?
I don't think so. I mean, I think obviously if you're going to be using big boom log trucks on a private driveway, someone else's private driveway, shared driveway, there should be some concern about that too. I'm concerned that my wife was almost killed.
I think if the DRB were to give them a permit to do it on its property, they would probably make it one of the stipulations that the bridge be up to code as far as, standards for, weight limit and all, because,
Well,
I mean, that would probably be part of the permit process, I would think. I don't know
Yeah,
if they looked at that when they made their decision, did they?
Well, they looked at what is rated by an engineer at 65,000 pounds.
Is that
But
Okay.
in any event, it's not.
And you use the bridge too, right?
Oh, yeah.
Yeah, so okay.
And that's the one that's deteriorating.
Right.
But it's not in the best shape right now. We talked once about redecking it. I redecked it with some 2x10s, Gordon helped some. But now that's degrading, and I have to replace at least one of them fairly soon, if someone's gonna put a tire to it, particularly a log truck.
So just try to keep us in no way minimizing the road or bridge issue, just try to keep us on track.
Right,
I think the road or bridge has to, I honestly don't even know what governs that, if it's just their private agreement or the road ordinance, or so I think we probably set that aside.
Well, is there a right of way that?
Oh, yeah, it's a right of way
Right of
shared
way
by,
to go through, so if there's a right of way, then he has a right to use that,
sure,
you know.
if he,
Now, the question I had in mind is, you can't stop a truck coming down a hill. You
well,
can't stop
that
it.
picture, no, not in that distance.
Well, There should be breaks, I would think. that
Well,
would
just
stop
again,
the truck.
Yeah, let's not get.
let's just to stay
Yeah.
focused real quick. Sorry, David, let's,
Okay, yeah.
the trucking thing, I think let's set aside for the moment unless anyone disagrees. I feel like we are already
Going all over.
trying to deal with the,
So we
firewood
can't deal with
processing.
that. It might be a state issue actually, as far as whether the brakes are adequate or not.
Well, no, it's not.
I'm not,
Let's not.
I'm not an
Okay.
expert.
There's only one other more point, and it's mainly as a taxpayer, the town of Underhill. We had a meeting with Jonathan Woods this morning. He's former Vermont Secretary for the Agency of Natural Resources.
Yep.
Fairly high-level position. Previous to that, he was Commissioner of Forest Parks and Recreation. Of course, he's been a logger, forester for 80 years. One point he brought up to us, which I was unaware of, in order to operate under the agricultural guidelines, you need to harvest at least 51% of the firewood logs off the property you're operating on.
Yeah.
You can import 49%.
Yeah.
Otherwise, it falls into Act 250.
Okay,
I just want to get that out.
okay.
This president, while he was in those positions, was established by a Shoreham court case. So there's a precedent set.
Okay.
Sorry if I diverged.
No, thank
the
you for,
subjects.
thank you for coming in.
I appreciate
And
it.
again, just to be clear, David, if you feel like you missed something, there's gonna be public hearings, so there's no,
Believe me,
not like speak now and forever.
oh, I know, and believe me, I was involved in the DRB
Yep.
meetings last year. I know.
Thank you, Dave.
Thank you.
I don't know who else is on, I can't see that screen, but does anyone else, sorry, we're in person, obviously. Does anyone else have, I guess it's just Russ or Gordon. Russ, do you have public comment? Gordon, do you have public comment?
No, I do not.
Okay, thank you, Russ. Gordon?
Yeah. Just to clear a couple of things up, the letter that was written, it, in no way with these guidelines that are written, would that deter a permit from being issued by the DRB. These are all personal instances. The road is a private driveway with half of it right away. It's not controlled by the town. It's not controlled by the DRB. It's a right of way from the pavement to my property. Then it's a right of way for Dave and Pam to their property. There's no governing on the driveway that the town can impose that is even a part of what this permit process is. We're not here to discuss people saying they're gonna shoot your dog or that they're running you off the road. And for the fact of the meeting that I'd like to say that I had complete control of my truck. I never touched the brakes. The engine brake is an engine retarder that stops the cylinders from moving as fast and it slows the truck down. It's not a braking system on the tires, it's a braking system on the engine. So your drive line slows down and it transfers the power from that to the transmission to the tires. I had complete control. She had pulled off the pull-off way before I even met their driveway, and I could have stopped anywhere at the point of that hill. I had got a CDL, I've had it since 2007. I operate these trucks. I did it for the town of Underhill. I do it personally. I did it for the town of Cambridge. I am a safe and very responsible driver. And that letter was nothing but slander and lies, honestly. The second thing is, the engine on the processor is a 74 horse engine. It is at the property line, which is 347 feet exactly. I measured that with my father yesterday to their front door. I did it with a rangefinder. The decibels that we read last year were 39 decibels with my wife during foliage season. The sound on a recorded device on a phone, it's in this meeting, it's going to sound different than standing right there listening to it. You can turn the volume up or down to appease your ears. So it's not going to give you the full effect. And if and when this goes through by the DRB, I will be more than happy to do a demonstration for anybody that is willing to attend. There are members of this board that have come up and watched the processor in process more than one occasion, and it's been easily seen from the road. And there are other neighbors that my wood business that is legally operated in Cambridge at this time affects and benefits. The town, 20% of the town burns firewood. We need to bring more people in that are cutting this. And this is why we're here, and we need to focus on that. Not who did what to who did this, or who got run off the road, or we're retired and have rights and stuff. We need to focus on the facts at hand, the most beneficial thing that will help the town of Underhill, not the personal, qualms between 2 residents or 3 residents or 4 residents. So if we can get back to it, I applaud all you guys on working as diligently as you can. And honestly, I see no issues with any of this. I can meet the standards set forth in the nuisance ordinance with my machine at the point that I'd like to put it on my property. I guarantee it, and I will have a professional sound company come out and measure it if I need to prove it. That being said, it looks great to me, and thank you for all of the board's due diligence on the matter. And if there are any questions about the machine, the log truck, or anything else that was in either of those letters or in the pictures, I would be more than happy to stay after and talk to all of you.
Okay, thank you, Gordon. Thank you, Dave. No other public comment? Okay, so let me just.
Could I look at those pictures? It would be possible to do that.
Sure.
Yes.
Does anyone have polls?
Here's the other ones went back to.
Is the wheelbarrow one?
Yeah, I'd like to see every one of them though.
Those are all the ones. I don't know what else.
Oh, that's the same one.
Mark, what pictures do you have?
I think the.
Same one.
Gordon has these.
Oh, okay. Okay, so, sorry, I'm trying to get my head together. So I guess,
Would it be helpful for me to review the changes?
that would be great, Larry. Thank you. Thank you for taking over, Larry.
Okay, so we asked for and got some very detailed comments and suggestions from members of the Development Review Board who are very familiar with the issue we've been just talking about, as well as the general challenges here. They took a critical look at the draft and made several suggestions. Some of them I kind of set aside because I felt like the draft addresses them. I did make some changes for conditional use review section, so it would have been on, I think the second page. Conditional use review, so proposed 4.18B. Initially, there was a statement that we would require for a sawmill operation, both conditional use and site plan review. And Charlie Van Winkle said, oh, every time we do a conditional use review, we already do site plan standards. We apply site plan standards. So it's like, I took that out, took the phrase out, site plan review. They suggested in section C, talks about exemptions. And the previous language said that existing sawmills or wood processing operations shall not be subject to non-conforming use provisions. And he said, whoa, time out. Actually, what you want to say is that it shall be subject to section 3.10, because that gets into some of the things that have to be noted and addressed if you're asking for non-conforming use permission. So we do want to make sure that when they're doing a review of a project, so seeking a permit, that they do have to address the section 3.10 standards for non-conforming uses. And then they suggested furthermore that, so I changed the shall not to just shall, I made the word not.
Yep.
And then setbacks, so that was under D, review standards, section 1, require minimum setback distance of, was 200 feet, now it's proposed at 300 feet from any residents on the adjoining property. So the clarification there was that if someone's allowing or doing a wood processing operation on their own property, they don't have to set up the machinery more than 300 feet from their own house. The issue is that the distance should be measured to houses, occupied residences on adjoining properties. So fix that. And then in D4, D is still review standards require the applicant to utilize noise reduction techniques. So they had a few tweaks on that. Because we had initially proposed that we would ask trucks to disengage a backup alarm, and somebody said, well, probably they have to have backup alarms. By state law, yeah. So I took that little piece out, and also just introduced more general language about other mitigation methods to address the sound. So I don't even pretend to know enough about this stuff to know what those might be, but there might be mufflers, there might be other devices that could be hooked up to the equipment that would mitigate the noise. So just other mitigation methods as appropriate.
I have one question, Larry.
Yes.
I know we've talked about this before, but I'm wondering, like, tonight has made me think a little bit more about it. Like, Dave said, I'm going to misquote these numbers, but it doesn't matter. Dave said I measured 90 or whatever Dave said. Gordon said I measured X. I don't know if he gave a number. I wonder, should we have like a little, like 3 words on like what's the standard? Do you see what I mean?
Yeah.
Like, because we don't want to create, our goal is not to create conflict or create gray areas.
Right.
So do we say like commercial standard? That's not it. But do you see what I'm saying now? No, I mean to measure the device. Like, what if Dave had the device and his says 90 and Gordon has the device and his says, I'm getting a ridiculous example.
I bought 3 identical ones, so they would all be the same right next to each other.
Like, yeah, what is there? There's got to be
I
a
was
standard.
suggesting a professionally licensed person to do
Or
that.
we could do
That was very similar to my answer. So my answer is that I think that under our land use regs, the DRB has the authority to hire an expert to take a close look at a situation that requires some technical review and evaluation. And the cost of that technical review and evaluation that the DRB chooses to hire to address a particular question or situation can be charged to the applicant. And we actually have provision in our town budget for the debit and the credit. So, and it's going to vary in each case. Like, you don't really know, in some cases it might be an engineer we'd want to hire for stormwater study. In other cases, it might be somebody who has expertise in sound mitigation, who you might hire to bring a professional decibel meter of some kind. And we don't have to get into all that.
You think we just leave it vague?
I think we just leave it up to the DRB's discretion to say if they feel like they need technical assistance in the form of professional evaluation of a situation to make an informed judgment on a conditional use review application, that the DRB can hire the expert and then charge it back to the applicant so that everybody's satisfied that this is a neutral information that's coming from expert rather than dueling apps on different people's phones.
Yeah,
because that's not a good standard for the town or good luck for anyone.
for sure.
Yes.
Where's that covered?
It's number 2, D2.
Yeah, and I do think, I felt like, we were, to the point that Dave made, it's better to have it reference the nuisance ordinance and to put a specific decibel number in there. Because, I think it's up to the town to decide what the appropriate level of noise that can be endured by neighboring residents for any source of noise. And if the standard that's in the nuisance, our adopted nuisance ordinance now is not the right standard, then fix the ordinance that's outside the purview of these regulations.
Right, so everything can refer back to the nuisance.
That's right.
Yeah.
And we're saying that you just can't exceed the nuisance ordinance. Sorry to keep bringing stuff up, I just want to make sure that we're all, it says 2 levels that do not exceed. It says it does not exceed the nuisance ordinance for more than 2 hours in any 24-hour period. But doesn't that leave a little hole in that, like, so could I test jet engines on my property for 119 minutes? And as long as I know it's ridiculous, but I'm not, but then the rest of the time I'm within the nuisance ordinance. Do you see what I'm saying?
I do, and
It's kind of a gaping loophole because there's then no restriction for 119 minutes.
I feel like this is a great topic for discussion at the public hearings, right? Because if people feel like 2 hours is too much, maybe it's 90 minutes, maybe it's an hour.
But should there be no cap in 119 minutes? You see what I'm saying?
It's easy that would be an easy fix if we get feedback in the public hearing that people think that there shouldn't be a limit.
Okay.
So I'm throwing something, I think we're throwing something out there.
You're trying to get this to the public hearing.
Exactly.
And then, so is there any, I was just reading through section 5.4.
Yeah.
Is there any, I didn't see it listed unless I'm just blind, which is very probable. Do all conditional use permits go to a public
Yes.
hearing? Okay,
Yeah,
so there's a
all-
30-day window, let it go out.
Yeah, you get notified.
All the adjoining
I
neighbors
saw
get
it in the section,
notified.
I didn't see it.
Yeah.
I just wanted to-
Right, and any neighbor who chooses to participate in that public hearing has statutory rights as far as due process. So they can, for example, if the DRB grants a permit for a wood processing operation to start up, and a neighbor feels aggrieved by that, they can challenge the permit in environmental court. And, the court can reverse the DRB decision if they feel like we didn't follow our own rules.
As long as
But if you weren't
hearing,
Yes.
within 15 days of the granted permit.
30 days
Is it 30?
I think so.
But if you didn't go to the meeting,
then you're out. You have to go to the
Oh,
county.
wow.
You have to go to the meeting,
Or
right?
at least sign in.
You have to be signed in and you have to speak or give written testimony. So you have to participate in it. So you can't be outside the process, wait until the process is resolved with a permit and then say, oh, I don't think this is right, I'm gonna challenge it.
I have one more comment, sorry. Just, I want to make sure. So the only remaining place that, unless I'm missing something, where I feel like there's a spread is just because like Dave just brought it up, is the setback. So I just want to ask everyone if they're comfortable with where the setback is in here, or if we're saying we're going to take this to the public hearing and solicit comment and then revisit it. Is that your recommendation?
Yes.
Larry? Okay.
right now we're at 3.
Well, right now it says 300, but I'm
300
just
is
asking
500.
process-wise, are we gonna take this to, or 500 for, are we gonna take this to the, is everyone comfortable taking this as is to the public hearing, hearing from people, like we know Dave doesn't agree with it, and then revisiting it? Is that the process that we're following, or do people feel like, no, 300 is not the right number, I think it should have been 200, or no, I think it should be 500? Is everyone comfortable taking 300 to the public hearing?
Yeah, I feel like for the sake of like, burying this on our table, let's move it on.
I did have a couple of questions about
Please.
this, though. On the setbacks, right now, it's just sort of like a, polar coordinate system. We're saying 300 feet door to operation. Are they still subject to any other setbacks within the property itself?
Well, I mean, I think it's a different answer depending on whether we're talking about a permanent sawmill with dedicated structures, or we're talking about a wood processing operation, which is portable equipment that can easily move around. Because setbacks in our ordinance relate to structure setbacks from property lines and distances, but there's no setbacks for equipment, other than what we might specify for a conditional use permit.
But there are setbacks for like fences and pools and that's.
Well, yeah, there's setbacks for tons of stuff.
Yeah,
Yeah.
but in general,
It's not like,
But not
it's
equipment.
like it's not a foundation tied to the ground, so
right, that's
it's a
right.
little more flexible in terms of.
Yeah, so we're making, to your point, we're making an exception here for equipment setbacks because of the nature of the operation. A lawyer or town attorney might look at this draft and say, you can't do that. But I think for discussion purposes, I think it's worth taking this to public hearing. And then following public hearing, we may want to make some changes, and then that would then go to the town attorney.
What is the typical equipment setback on?
We don't have equipment
Where's that?
setbacks in the ordinance.
We're adding on another
Sometimes
layer.
you need to have equipment close to a boundary, basically.
Yes.
Does that answer your question?
Yeah, it answers my question.
Do you
No, I'm just feeling like, you know, it probably would make sense for something like this to not be necessarily put right on the edge of the property.
Yeah.
In general, because it isn't permanent, but it's kind of semi-permanent.
It depends.
Right, for a while. So that's one thought. And then the other thing is just going back to, you know, the topic of safety and if the roads are designed for everything. Is that all taken into consideration in the conditional use review? Or like,
Yeah.
is that
I would
putting
think,
in here? I mean, there's gotta be a permitting process.
I would think it would be. I mean, I think
Trucks,
part of the questions that DRB would ask in a conditional use review for any operation that's commercial or feels like it's getting into commerce would be, and you know, this goes to site plan review as well, would be, is the property set up to handle the truck traffic, the water flow, the electric demands, the lighting? I mean, they look at all those factors in conditional use review, and if they feel, for example, that the driveway, which was designed and built for residential access only, is not built for heavy trucks, you know, they could say as a condition of approval, if they're inclined to approve a project, you have to beef up the driveway.
It's in.
Yeah, it was just.
Under 5.4, the traffic on roads, highways, and vicinity. So DRB shall consider projected impact traffic resulting from the development on the condition of capacity, safety, efficiency, and the use of existing.
Okay. Yeah, I just wanted to make sure we weren't creating like a loophole.
Yeah.
And say, okay, it's fine, set it up, and then it's like. But there's, you know, you don't have to get the permits for the roads or something, like the bridges.
I, once again, would like to go on the record and say that I'm opposed to 300 feet. I think 200 feet is plenty, and when you take a look at other towns in Vermont, what they've set limits for wood processors, you know, they're down to 50 to 100 feet. So 200 feet is plenty.
Did you hear that part? Dave asked which towns?
What?
Which towns?
Facein, Williamstown, and a couple. And I haven't looked at those for a while, but.
So it sounds like, does anyone else have any questions or comments on this? So it sounds like, Larry, just to repeat for the record, what happens now is we vote, if everyone's Bart's objection is noted, if we all approve this, then we schedule 2 public hearings where the public gets their say on all this stuff, including setbacks. And then it circles back to us and we take that into consideration. And then we send it to the lawyer and see if she or he says we're wrong about something despite all of that. And then it goes to the select board, correct?
Yeah, and typically if we make significant changes in this draft, after that
Then
first
back to
public hearing, then we have to do a second public hearing. It's the same thing for the select board. So the select board can take our vetted draft and they can propose changes to it. And if they do, they have to have a second public hearing too. So we're looking at a minimum of 2 and most likely 3 or 4 hearings on this.
Okay. With that, if there's no other questions or comments, then it sounds like we should vote on this, get the public hearing process going. And so we can get folks' thoughts and move forward.
I just got a question about
Yeah.
the setback. How did we come up with 300 feet? Was it just,
I don't know, because it started back with, like Dave said, it was 500 feet, then it was 200 feet, now it's 300 feet.
Yeah.
For me, the most open item on this, and where I'm curious what people say, is that number.
Yeah.
For me, that 300 feet is like almost a filler right now. We're like taking that to public hearing to see what people say.
I mean, you know, Bart's public comment is 200. Dave's public comment is 500.
Yeah.
So it's, ours right now is 300 as public comment, so it could go to 250, no, you know.
And then
It sounds like the 300 is ambiguous anyway. It's really
in the end,
the frequency and
it's the
hertz,
I have
right?
a copy of this.
Yeah.
It's the decibels.
Oh, we all have it. Trust me. Thank you.
Right, and I'll just say that, you know, the DRB had questions about that as well, and you know, my feedback was, well, you know, the issue is that how you perceive the noise, whatever distance it is is affected by so many variables. So you have, the seasonality, like are leaves on the trees or not, you have the terrain, maybe there's a hill or
The
something
direction
in
of the
between,
wind.
the wind direction, the ambient humidity in the air, and there's so many variables.
The
So,
topography.
yeah, topography, exactly.
You have your hearing aids in? Say it.
Wasn't that handy? You can just
Take them out. There you go.
You can just take that noise level right down,
Yeah,
Ron.
I don't hear anything.
Okay, well, I think that if everyone's, take this to the next step, I will make a motion that we approve this draft and schedule some public hearings. Do we pick the dates here, Larry? or-
We don't have to.
Okay.
We can just look at our calendar.
All right, well, we'll look. We'll not do that.
There are statutory requirements as far as notifying,
Okay,
not just, you have to publish in the paper a certain number of days in advance, you have to send a copy to surrounding
Okay.
towns. So all the folks who might be affected in nearby towns can know that you're working on this and to comment on it, so.
okay.
Will the public hearing have more than one, will ADUs be on the same public?
No,
hearing?
no.
You gotta have it.
Well, we could, I don't like contradicting Brian, but, I mean,
Very stressed.
Well, we're not even done with ADUs yet.
it's a choice. So, when we did this in Charlotte, we typically bunched them together. Just because it's more efficient if you have to pay to advertise something in a newspaper to choose a couple things that you think are ready for hearing, and then you just do them sequentially on the same night. But that's.
If we think we can get through ADUs tonight and have trails done, then I would love to have a public hearing for all three of those. Because as far as I'm concerned, well, trails is done. We just need the memo from Larry, and ADUs were done until David brought it back up. No, not Dave, David. So, okay, why don't we decide if we're gonna put all three of them in one public hearing? Let's get through the meeting, see if we finish ADUs, and then we can maybe make that call.
Okay.
All right?
Yeah.
But to accomplish that goal, I make a motion that we approve this draft and set up 2 public hearings. Is there a second?
I second that.
John, thank you. And all in favor?
Aye.
Aye. Can't see David. I'm assuming he said yes. He's not there. Oh, he's there. Hi, David. Are you in favor?
I saw yes.
Yes. Oh, he said yes. His mic's not working. Okay, so that's
Apologies,
unanimous.
yeah. All right.
Thank you, David.
There we are.
Okay.
So is that unanimous? Did I get
Yes,
that?
it's unanimous.
Okay, thank
Everyone's
you.
in favor. Which takes us to ADUs. And I just want to say thank you again. Obviously, you guys are welcome to stay, but thank you again, Dave.
Thank you,
Gordon.
guys.
Thank you, Russ. Thank you, Michelle. Okay.
See ya.
All right, this takes us to ADU amendments, including David's email that he sent around, which I'm pulling up right now.
I'm sorry I can't send things out from, a document. We still haven't gotten that straightened out on my iPad. But anyway.
David, do you mind maybe just opening with explaining your, I mean, I read it,
I can
obviously.
go right through
Yeah.
it. It's really,
Match this.
concise and not too much. All right, so, as far as, 8.6.
I'm just passing these out, you can go there.
Okay.
Thank you.
Yes.
Roy, you want?
Oh, yeah, thanks.
Okay, sorry, go ahead, David.
All right, so we're working from the ADU standards redraft, 5/19/25. Okay, so my first point is rewriting 6, to read, in accordance with accessory structure regulations, the accessory dwelling structure shall be located within 400 feet of the principal dwelling unless otherwise waived by the Development Review Board. The reason for the opening clause in A6 is to be clear that the governing regulation is for accessory structures as distinct from accessory dwelling units. Why is that important? Because the Vermont statutes mandate that regulations governing accessory dwelling units shall not be more restrictive than those governing single-family dwellings. We're talking about structures and not dwellings. And the structures have a different regulation than dwellings. So that's the point here, and that's what we try to keep perfectly clear. And Lee brought that up a year and a half ago as it being a confusing point. Clarifies.
Do you have thoughts? Sorry to interrupt, David, just before we move on, do you have thoughts on that?
I did actually make 2 changes to the draft and reposted it, and I want David to finish his presentation.
Okay, sorry, go ahead,
I'll
David.
talk about how we address it.
So we'll finish on this. Okay, Vermont statutes mandate that regulations governing accessory dwelling units shall not be more restrictive than those governing single-family dwellings. Single-family dwellings, when there's no, single-family dwellings have no restriction regarding location, basically. So if you put a restriction on the accessory dwelling units, that's more restrictive than the single-family dwellings.
Well, a
And
single-family dwelling has restrictions on its location with, a building envelope or.
If it's in a building envelope, it can be the same as the single-family dwelling, but it can't be more restrictive.
Okay, yeah.
Yeah, and this is saying that it will not be more restrictive than a single-family dwelling. This is saying, A6, what I'm having here is in accordance with accessory structure regulations, the accessory dwelling structure shall be located within 400 feet of the principal dwelling unless otherwise waived by the Development Review Board. Do people see the difference here? The difference between a structure and a dwelling unit, and regulating the structure rather than the dwelling unit.
Yep.
Is that
David, will
clear?
you refresh my memory on this 400 feet? Did we make it 400 feet to make it easier to build another ADU?
The 400 feet is more restrictive than what we have now because it could be, if it were 1,000 feet away, you could put it anywhere on your property. But if it's 400 feet.
I thought it was to keep.
A little explanation on the 400 feet.
Well, it's
The 400 feet are set up, it was an idea that I brought along so that properties that have, say, 15 acres in the 10 acre zone, you could, without this 400 foot limit, you can have your primary dwelling on one end of the property and then run a driveway or something all the way to the other end of the property. And it's just more intrusive on the forest, basically. Or you could, if you had a road on the backside of the property, you could put it there rather than up within 400 feet of the main dwelling.
It's
So
also
to preserve forest land, basically.
It's also a bit of a loophole around subdivision, right? Like, I mean, you're not technically subdividing it, but like, the reason we have all these rules, to David's point is, without the 400 feet is, it's a pretty big loophole around subdivision, right? Like, why do we have all those rules to begin with? If you could just go put a thing on the other side of the property and it's effectively subdivide it, right?
It wouldn't be something.
You're not legally subdividing it, but you're, a lot of the reasons that we have all these rules, like forest fragmentation and all this other stuff, without this, it's essentially a loophole around it, in my opinion.
Well, it wasn't part of the motivation too that.
And also you have to live with it.
Right, that if someone's building an ADU to set up a short-term rental situation,
This is my main.
requiring that the ADU be within, sight distance of the principal dwelling, does create some level of accountability as long as someone, the owner or someone from the owner's family lives in the principal dwelling.
Right.
Which of course, we can't really police that once these things are built. So that's a dilemma that it's a conundrum.
It's in the regs,
You can't really say fix.
It's in the regs.
Well, that's
Yeah, but how do
part
you-
of what the draft
Nobody
says.
enforces it in the regs. you know,
No, but it's,
maybe if somebody really complained, they.
well, but yeah, then why have any rights, right? Like, you could make that argument about anything.
To your question though, is there a way that somebody could sell the ADU that they've built?
No.
You'd have to go through the subdivision.
They had to own it, and that means it can only be rented.
Right.
You would have to have the
Well,
right acreage
yeah.
to begin with.
Hmm?
You would have to have the right acreage for the,
To sell.
Subdivision,
You have to be big enough to subdivide. I mean, my main point was what I agree very much on the forest fragmentation and everything David said, but my main point was like, if you're gonna have an ADU that's a short-term rental, which let's not kid ourselves, but most of them are, you should have to live with it. So you shouldn't be able to put it on the opposite end of your property, like 50 feet from your neighbor's house and 3,000 feet from your house.
Right. And this is, I'll just say it's a bit of a crapshoot, pardon my French, as far as whether this will survive legal review. So, I mean, I really appreciate David's attempts here to try to make this conform with state statute. But, you know, whether the town attorney will say we can do this or not is an open question.
Yeah.
So I think our intent is pretty clear at this point. We've talked about this many times, including before I got here. And as long as we agree on the concept and that we want this to be in the draft that goes to public hearing, I think we're good for now. And then if we're full of, you know what, the town attorney will tell us you can't do that, and we'll fix it.
I think this is the only way to at least make it arguable.
Yes.
So we can go with that anyway.
And do you want other stuff you want to go over in your second point?
Okay, on to A7. I wanted to add after 6, another line, A7. If the accessory dwelling unit is to be within an accessory structure, the regulatory setbacks for accessory structures apply. All right, I'll continue on reading this. There's several reasons why. The reason for A7 is to facilitate the development of accessory dwelling units by reducing the sideline setback requirement to help Underhill meet state housing goals. Outside the village district, the sideline setback requirement for the 4 districts for accessory structures is 20 feet. For A7 allows 20 feet to be the sideline setback for accessory dwelling units. All right, now for primary structures, 2 of those districts have a 75-foot sideline setback. The other 2 have a 50-foot sideline setback. The sideline setbacks are not entirely for privacy, but to ensure that development in Underhill does not proceed with narrow spaghetti lots. You have to be 75 feet from each side of your property. Your property has to be blocky to a certain extent. You couldn't have in say the 15-acre zone, a lot that was 200 feet wide and 5,000 feet or whatever it is, running off into the forest, and could have a line along the road of 200-foot frontages. So part of this setback has to do with avoiding spaghetti lots. It's not all about privacy. Okay. Let's see. In fact, you know, if you have 20 feet from the sideline plus the neighboring primary dwelling of 75 or 50 feet, that allows for plenty of shrubbery. You've got 20 feet plus 75 feet on the other side where the primary dwelling is, or 50 feet. So you get either 70 feet, these are minimums basically, or 95 feet. So seems like plenty of room.
I have a question though, David.
Yes.
Sorry, I see you put this in here already, Larry, and we can debate it, but I don't think I agree with this, and I'll tell you why. Because if we're worried the 400 feet is gonna get knocked out, or if that's a possibility, then why would we do this? then you're making it so you can put it just closer and closer to your neighbors. Like if the 400 feet goes away, let's say the lawyer says you can't do the 400 feet. I could see why we would do this. To me, these two issues are somewhat interrelated, and I would be very hesitant to allow this without knowing whether we can get the.
Yeah, I disagree.
Well, obviously, you
Yeah,
wrote
right.
Can I ask another ignorant question about our zoning? So I know like we have kind of general zoning, but you mentioned like there's 10-acre zoning or 15-acre, whatever it is, right? So with those specific zoning types for acreage, is there like a minimum lot width defined in that? Like it has to be a minimum frontage of 200 feet. Is that in the zoning definitions for those specific?
I think those spaghetti lots are a thing of the past. I think anybody who has any land they're gonna subdivide
Yeah.
today is not gonna do that. You
Well, I
know,
was
they're
just
going
curious
to.
if we just have it, because like I know like,
Larry's got it up on
okay, so,
The frontages make a difference, certainly.
but like a minimum lot width, is that on there?
Yes,
It's the minimum frontage.
the minimum frontage.
So that's obviously not,
Yes.
okay.
So it's different from district to
Yeah,
district.
yeah, okay, yeah.
So in the rural districts, conservation districts, it's
Yeah, so-
300, 400.
So that basically kind of, keeps you from getting too spaghetti.
Part of it, yeah.
Well, and spaghetti lots are a function of subdivision, drawing new lot lines in a subdivision rather than what we're talking about here, which is building on an existing lot. Yeah, and the spaghetti lots really are an artifact of the Act 250 rules and legislation. So, in Vermont, after Act 250 was signed into law, they said any lot 10 acres or more had to fall under Act 250 jurisdiction. And, people went crazy with creating these long, skinny 9.9 acre lots. So, they made them as wide as they needed to be to meet the town's frontage requirements of where it fronts on the road. And then they went back 9.9 acres. And if you look at a map, you can see a lot of towns have a lot of spaghetti lots that were created because of that somewhat unfortunate provision within Act 250. Because they could have seen that coming and they didn't, and so that's how we ended up with so many spaghetti lots.
Yeah, there are a whole bunch over on the Bunker Hill Road.
Yeah.
Well, okay,
Yeah.
continue.
Oh,
Okay.
could I jump in for a second?
Go ahead, David.
Yeah, just because I do agree that the 400-foot piece, as that interrelates, is a little problematic, and there's a possibility that there could be a place, where more than 400 feet is accessible. I know having the development review board having a place to be able to override that may work, but I appreciate the intention David's going for with protecting forest, and maybe there's a way. I know everyone might be tired of redrafting this, but rather than putting those measurements in place, maybe there's specific language to protect forest land rather than make it about measuring. But it's just a thought.
Protect forest land or not.
I gotta share something here too. I've been against the 400 feet since day one because I think about somebody who might have a 1,000-foot driveway, okay? And the first 400 feet of it is through a field, which would be a great place for an ADU. And then their house is 600 feet through the forest. So they would they would have to go 200 feet into the forest and clear, to build a house, you got to clear probably half an acre. So that would fragment the forest. And I can think of a situation where I looked at a piece of property with this intention, and it was like, yeah, if it was 400 feet away, it would be the worst place on the property instead of in the field where it wouldn't fragment the forest.
Well, it allows, unless otherwise waived by the development review board. So there is a loophole there for a situation where having that ADU more than 400 feet, if it's desirable, or the
Yeah.
structure, or
Right, so why even have it in there? Why even have the 400 feet in? Because anybody could just go to the DRB and get them to waive it and put the ADU where they want.
I don't think it's wide open. Okay, you have to have a reason, basically.
I think the point of including it in the draft is to show legislative intent. And it's up to the DRB to interpret that, right? So the DRB can grant waivers willy-nilly, or maybe they would feel like, the legislative intent here is pretty clear that we want ADUs to be located close by the primary dwelling. And, and point of fact, most ADUs are gonna be pretty close to the primary dwelling just because of septic connections.
Right.
It gets real expensive
Oh, yeah.
to build a separate septic treatment system in leach field and all that stuff
Mhm.
just for an ADU.
Right.
So most ADUs are going to be within spitting distance of the primary dwelling for that reason. The economics will drive that site selection.
I thought we had a discussion too, just about having some sort of relationship between the two buildings. You had a house and then a larger house and a smaller house, and how they complement each other and kind of control the look, the aesthetic of the open land that looks more contained, as opposed to if you have it split apart, it's just, like you said, it's just two lots, and then you're basically potentially doubling the housing aesthetically throughout a rural district.
Yeah.
So, can I continue with, just, a little further reasoning?
Sure.
Requiring accessory dwelling units to have the same sideline setback as primary dwellings creates awkwardness and hindrance for the development of accessory dwelling units. For example, consider a garage that's set back 65 feet from the sideline with a required primary dwelling setback of 75 feet. So it's 10 feet over the line from a primary dwelling. If you had a garage there and you wanted to put a ADU in that garage, remodel it for that, you'd have to partition it up 10 feet basically, right through the middle of the garage. And that just seems kind of awkward, really, and for what? So let's, if you have that situation, and then suppose you do have a garage that's actually totally within the that setback. Say it's it doesn't come into over the 75-foot line at all. It's totally within that. You just wouldn't be able to use that structure for an ADU. You just have to build a whole new structure, basically. So having the 20-foot sideline setback for structures will help to increase ADUs, provide less awkwardness and restrictiveness. It'll help housing to a certain extent and also help economic development. So I think it's a good thing to do it that way. And I don't think there's any real hazard in not doing it.
But if you're talking about 65 feet for the garage, 75 feet for a house, right? The setback, that's in the.
Talking about it as an example, basically, just a hypothetical.
Okay.
Hypothetical, if you have the garage that's set 65 feet.
The detached garage.
Yeah, detached garage that has one side 65 feet and the other side is over the line, basically, beyond 75.
David just doesn't want the setbacks to apply. And he wants the accessory structure setbacks to apply to ADUs, not the primary residence setbacks.
Yeah, right. That's I think we all decided on that, right?
So would you like to know how I fixed the draft?
Yes, Larry, please.
And,
There are a couple other small things.
okay, so I just, the simplest approach here, I thought, to work with the existing language and to fix it, to address David's concerns, was first of all, to make sure that, so at the very top, in the first paragraph, we've already defined accessory dwellings as a unit that's accessory to, within, or attached to the principal single-family dwelling, or within a structure accessory to the principal single-unit dwelling. So we've already defined ADUs as being either attached to or physically separate from the dwelling. And by definition, if it's physically separate from the dwelling, detached, in other words, then it is an accessory structure under this introduction here. But then down in A6, so David wanted us to change A6 to make it clear that we, in that situation of a detached accessory dwelling, that the accessory dwelling needed to be located within 400 feet of the principal dwelling unless waived by the DRB. Well, that only applies if the accessory dwelling is not attached to the principal dwelling, right? Mm-hmm. So if, however, you're converting a garage that exists or converting a barn that exists on the property already, then it's a different set of rules that apply. And so I added the language that's highlighted in yellow here, constructed primarily within an existing accessory structure, because if that's what you're doing, then the 400 feet standard is kind of irrelevant because it is where it is. It's where you propose to put it. And if you're asking for a permit to do that, then the rule applies unless otherwise waived by the Development Review Board. So then you're looking at what are the standards for accessory structures and setbacks. And we actually, I mean, that is really the only standards that we have in the whole land use regs about accessory structures is setbacks. We don't regulate their size. We don't regulate their height any different than any other structures. We don't regulate anything else about them because they're all over the map, right? You know, it might be a two-story barn. It might be a chicken house that's enormous structure. It might be any number of different kinds of structures can be considered accessory structures in connection with a residence, and they are where they are. So I went back to the land use regs, to this table here we were looking at a moment ago, and right here in this line, which goes right across the chart, it says what the setbacks are for any accessory structure from the front, from the road frontage, from the side yards setbacks, and from the rear. And they're much more generous than they are for houses. So houses require bigger setbacks than accessory structures if you're building new. If they already exist, then they are what they are. And you're going to have many situations where someone is interested in converting a garage or a barn that's already up into an ADU because they already have the foundation, they already have wiring probably, and maybe they have some plumbing in it, and they can just do a renovation and make it happen. So these setbacks only apply for building a new accessory structure, and they are already reduced. So back to the draft here. So if you're building primarily within an existing accessory structure, then the 400-foot setback is irrelevant. Or if you're building a new accessory structure and that's under B, then you have to pay attention to the setbacks that are allowed. However, it's an accessory building, so the setbacks are lower to begin with. And if you want to go even closer to the property line than what the accessory structure setbacks are on a given property, then you have to go to the DRB and get a setback waiver. And that's public hearing. Neighbors can comment on that. People can object. The DRB can set conditions, say, no, you can't go that close to the property line. You have to pull it back a bit. So these things are all able to be addressed without getting into the nitty gritty of is 50 feet enough, 75 feet enough. That's really under to the discretion of the DRB in this language because it anticipates the two broad categories, sort of actually three broad categories for possible ADUs. So one is that you chop up your house and you make part of it into an apartment, and that's your ADU, separate dwelling unit. Second category is you attach the ADU to your house. So third category is completely separate structure. And this language, I think now, with taking insights from David's suggestions, accommodates all three scenarios. And it gives the DRB discretion to say, no, it's too close to the property line, if they feel that way. And then you still have your underlying legislative intent that if you're building a new structure, putting your ADU in a new structure, that the legislative intent here is that it be within 400 feet unless it's waived by the DRB. So I think that gives property owners maximum flexibility. It gives the DRB the discretion to say yes or no.
Mm-hmm. So basically, we're talking about 6, and you're saying that you'd rather not have the opening clause that I have there in accordance with accessory structure regulations.
Yes, because there aren't any, David. Well, that's my point.
The point was to be distinct with accessory structures and have them defined clearly as accessory structures and not confused with an accessory dwelling unit. So, I don't see that there's any harm in including the accessory dwelling unit being, in accordance with accessory structure regulations. I think that helps to clarify the fact that it is distinct.
The setbacks are distinct for accessory structures.
Well, it's distinct from an accessory dwelling unit. The structure is.
I think accessory dwelling is a flavor of accessory structures. That's my point.
Yeah.
It's
I
a
mean,
type.
an ADU has to be somewhere. It has to be in a structure detached or in a structure within the original structure. Like, it can't just float in an imaginary bubble. Like, it's got to be in one or the other. I feel like that's kind of, I don't know.
Yeah.
Assumed.
And this is, I think this is very flexible, as it should be. I mean, I agree with your intent, which is to make it as straightforward as possible for people to put in ADUs. And I think this accommodates all three options.
I have one thing from Brad, sorry. Brad said that ADUs that are gonna be open to the public have to meet some fire regulation from the state. Should we reference that in here? or is
You
that
already
not
give your
worth referencing?
permit application for that when you.
No, I'm just saying, should we reference that here or not?
So, no, I don't think so, because it's a separate topic. The short-term rentals are a separate topic. Any property which is rented for the
Oh, I
public
see what you're saying, so it doesn't
has to
matter,
follow state fire.
because you could be
Yeah.
building it for your mom and then it doesn't apply, or if
Exactly.
you're building, got it, okay. Wasn't sure if we needed to adjust that, sounds like no, okay.
So I had another clarifying question.
Yes.
Sorry to go there again, but, so if it's an accessory structure, you showed these setbacks before,
Yes.
they can build that close. But there might be existing structures on properties that don't even meet these.
Right.
Is that?
Right. Yeah, so these standards for each of the zoning districts pertain to if you're building new. But we can't outlaw structures that
Yeah,
already
if there's a
exist.
barn that's 150 years old, because none of this existed then.
Right,
It's
right,
there.
right.
Or the
Okay.
property was split.
Everything that's
Or
already built is grandfathered to continue. So we're talking here about new.
So if your barn was 5 feet away from the property line, then, and you were the neighbor, you would presumably show up at the DRB hearing and
Yes.
want some assurances regarding that.
Perhaps.
Yeah.
So they could
Yeah.
deny your request to convert it to an ADU if enough people were upset about it.
Yes.
Well, I think these are great changes there.
Yeah.
I think they're really good.
Yeah, and then David also had a comment on this table here. And so on table 4.3, this particular piece that's outlined in yellow now. So just clarifying that either it's attached to the principal dwelling or part of it, or if it's detached, it has to be within 400 feet, except for the two clauses that we were just talking about. So if someone feels like they want an exception to that rule, and they have to go to the DRB and ask for a waiver, and then the DRB either would or wouldn't grant the waiver. So I think this table, I did correct this table to reflect that, the fine tuning in A6 and in B here about accessory structures, and that waiver. So unless waived by the DRB.
So are people comfortable with this, or what, I guess, what?
So what about or so you're saying the A7, you don't want that in there? That's saying if the accessory dwelling unit is to be in an accessory structure, the regulatory setback for accessory structures apply.
They already do, David. It's just reiterating what's already in the standards.
If we have the accessory structures allowed to be within the 20 foot from the sideline, then you can't really put a dwelling unit in there, an accessory dwelling unit in there.
Well, if it's an existing structure, then that the setbacks don't apply because it only fits a new structure. It's grandfathered.
Yeah, right, it's an accessory structure, but you can't put an accessory dwelling unit in that accessory structure.
I think you
Because the
could.
dwelling unit
You can.
the setback
You can.
has to follow the regulations of the primary dwelling.
not the way Larry has this written.
Yeah, if you can accept, you can request a
I
setback
don't
waiver.
think Larry's writing covers that.
It's
Sorry.
grandfathered.
Well, it's, where do you think it's not covered, David?
Well, you have to clarify that, an accessory dwelling unit is going to be allowed.
I think it's in section B.
It's in B.
Yeah.
It just says you can't
It's not an
increase
A7,
the
it's
degree of
In
nonconformity.
B,
Yeah,
it's
you
all
made your
B.
change, but it's in B.
where?
It's in the last sentence, lines 4 and 5.
Yeah.
So
An accessory dwelling unit proposed to be built within a new structure
that would be non-conforming
that would be non-conforming.
with district setback standards for accessory structures may be allowed upon approval of a setback waiver by the Development Review Board under section 5.5, provided it is otherwise compliant. So if you're following all the rest of these rules, then you go to the DRB if you want an exception for the accessory structure setbacks as stipulated in table 2.1. DRB could say yes, or they could say no.
Okay, all right.
So no pressure, but time-wise, if either people are comfortable with, again, no pressure. We either can vote on this and say we're good with it, or we can say we want to revisit it next meeting, but we have to do this executive session thing tonight. And it's going to take like 3 minutes. So, and I know everyone wants to get out of here. So, do people want to vote on
No, it's all right.
ADUs or do it next meeting?
Oh, no. Okay.
Well, I can vote on it.
Yeah, well, I'm good.
Someone want to make a motion to approve these ADU? Tim, second. Roy, all in favor? Aye. It's unanimous.
Yes.
Okay,
I would never.
Thank you,
accomplish
Tamid. Okay, so real quick, Larry, so for next meeting, do you think it's possible to have the trails thing like you do all of these?
Yeah, I'll do
And
my
then I
best.
think we try to do-
I'm actually out of state next week.
Okay.
But I will try to
Well,
at
maybe
least
you
draft
and I
it.
can touch base over.
Yeah.
Okay, real quick, does anyone have any question or comments on the May 22 minutes?
No.
I make a motion, we approve the minutes. Is there a second?
Second.
Bart, all in favor?
Aye.
Aye.
Thank you, Tweed.
Sorry,
Okay, those
who,
pass.
can you reiterate who moved it seconded?
Second by Bart, motion by Tim.
Oh, I wasn't here last week, I couldn't.
Oh, sorry. Roy, did you have?
I did.
Right.
I did my hand right. Same time. you did.
Sorry.
So Roy moved?
Yeah.
And who seconded?
Bart.
Bart seconded, thank you.
Okay, I'm gonna make a motion that per 1 VSA 313, we go into executive session and stop the recording
Discuss a personnel
to
matter.
discuss personnel. Thank you, Larry. Once again, it's critical that Larry is here. Are we off?
Just not yet.
Okay.
Nobody, you haven't voted yet.
Oh, is there a second? To be guys second, all in favor?
Yes,
Aye.
Yes.
This conference will now be recorded.
So I make a motion that we come back out of executive.
Yes.
Session. Yeah. Okay, I would like to make a motion that we come back out of executive session to discuss a personnel matter. Is there a second?
Second.
Thank you, Zach. All in favor?
Aye.
It's unanimous, which now takes us to our final matter of business, which David traditionally makes for us. Do you have a motion, David? Motion to adjourn. Is there a second?
Second.
Bart, all in favor?
Aye.
Okay, thank you, Tamid. Nice to see you.
Thanks, everyone.
Thanks.
I'll see you in person next time.
Yes.